and very timely. This one of the problems with giving talks, making remarks, and addressing international privacy developments and cross-border data flows is that you can never give the same set. If you prepared the remarks 3 or 4 weeks earlier, you have to redo it all. There's a constant flow of developments. Here we're going to be talking to some extent on the Schrems II decision of the Court of Justice of the European Union back in July, the kind of point-counterpoint rebuttal of the or paper responding to the decision, the white paper of the Office of the Director of National Intelligence, DOJ, the Department of Commerce on Schrems, one of whose principal architects, Sujit Raman of the Justice Department, I'm now very honored and pleased to report, is a member of our privacy and cybersecurity group at Sidley, Austin, as of last week. There's also the Privacy International decision that I expect that we'll be addressing of the Court of Justice just last week, and the pas de deux of the Conseil d'État and the CNIL in France regarding privacy developments there. So there's very much to talk about. My guess is that while there may be some consensus on the fascination, the interest, and importance of our subject at hand here, little consensus, I would imagine, on both sides of the Atlantic regarding possible double standards between the application of EU privacy and national interest standards to the United States versus EU member state governments, the need for convergence and engagement of governments, and the importance of digital commerce as a trade matter to ensure that the invaluable data flows between the United States and the European Union continue. This is not just, and I trust that our distinguished panelists, who I'll introduce in a second, will comment on this. Of course, it's not just US and EU. There is the rest of the world too. Unfortunately, Catherine de Fontenay of Australia, who was going to join at the last minute, there was a conflict that arose. So I apologize that we don't have APAC represented here, but I know that our speakers have a tremendous breadth of knowledge, experience, and I think we'll cover the world as well. Our first speaker, I'll introduce all of the speakers and then turn it over to each of them for some introductory remarks, and then we will begin kind of a bit of a roundtable discussion, I hope, and certainly address your audience questions, as Scott indicated, by typing the questions into the website sli.do. So Bruno Gencarelli is the head of the International Data Flows and Protection Unit of the European Commission. Bruno heads, he has led the Commission's work in the area of data protection in the decisive phases of legislative reform in the EU and US negotiations, which I think is certainly a lifetime employment opportunity for him. In that capacity, he headed the EU Commission's delegation on interinstitutional negotiations with the European Parliament and the Council that resulted in the adoption of the General Data Protection Regulation and also the Law Enforcement Directive. He was one of the lead negotiators in the EU-US Privacy Shield and Umbrella Agreement, and recently negotiated the Mutual Adequacy Arrangement with Japan. He previously served as a member of the European Commission's Legal Service and as an assistant référendaire to a judge at the European Court of Justice, having practiced law in the private sector before that. He holds degrees in law and political science and teaches EU competition law at Sciences Po Paris, and he's the author of numerous publications on EU law. Dr. Andrea Jelinek is the head of the Austrian Data Protection Authority, and she became the head of the Austrian DPA in 2014. She holds a doctorate degree in law. While a student, she worked as a consultant at the Austrian Science Fund, later as a trainee lawyer and legal officer in the General Secretariat of the Austrian Rectors Conference. Later, she moved to the Ministry of Interior, where she worked as a legal officer, and later as the head of the Department of Legal and Legislative Developments. One of her specialties, asylum and immigration law, helped determine her further career. She was later head of the Vienna Foreign Police, and before that, she was the first woman in Vienna to be appointed head of a police commissioner's office. She then became chair of the Article 29 Working Party under the prior directive on data protection, and Dr. Jelinek now serves as chair of the European Data Protection Board. Kenneth Propp is a senior fellow at the Atlantic Council and an adjunct professor of law at Georgetown. He is a senior fellow, non-resident senior fellow on the Council's Future Europe initiative and consults for technology companies on transatlantic digital and privacy law and policy issues. He's a contributor to the very invaluable Lawfare blog, and also he has served as a director of trade policy for the Business Software Alliance, BSA. And from 2011 through 2015, he was a legal counselor at the U.S. mission to the European Union in Brussels, where he led the U.S. government's engagement with the EU on digital privacy law and policy. He previously was a senior attorney in the office of the legal advisor at the Department of State, and he served as legal advisor to the U.S. Embassy in Germany. He holds a law degree from Harvard Law School and a bachelor's degree from Amherst College. So with that, you can see that we have a supremely qualified and distinguished panel, and we'll turn it over to Bruno Gencarelli of the EU Commission for introductory comments. Bruno?
So thank you very much, Alan, and also to TPI Aspen. Very honored and pleased to contribute to this event, even if only virtually. Very happy also to be in the same, saying also hello to my co-panelists, which are not only excellent colleagues, but that I consider friends. We have been working together on these issues on different sides for many years. I guess that in this panel, you will want us to dive in the complexities, intricacies of the recent European Court of Justice case law and its implication for privacy and data flows, in particular from a transatlantic point of view. I'm of course ready to do this, but maybe it could be helpful to start this conversation, to step back, to make a step back and put these issues into a broader perspective. When looking at this broader perspective on privacy and data flows, I think that there are two considerations to keep in mind. First, it might sound obvious, but in today's world, and increasingly, the demand for the protection of personal data knows no border. It's a truly global phenomenon. It's a question of course, individual rights, as recognized by many constitutional frameworks around the world. It's a democratic imperative at a time when the functioning of our democracy and the integrity of our electoral process can be threatened by the misuse of data. It is also an economic necessity. Without consumers' confidence in the way their data is handled, in particular online, there can be no sustainable growth of our increasingly data-driven economy. And what is interesting, I would say even what is remarkable, is that as countries, societies around the globe are facing similar challenges and trying to seize similar opportunities when it comes to digital economy, they tend to equip themselves increasingly with new or modernized privacy laws that tend to share a number of commonalities in terms of safeguards, in terms of rights, in terms of enforcement mechanism. And this is a truly universal trend, running from Chile to South Korea, from Brazil to Japan, from Kenya to India, just to mention a few examples. In fact, in a world that is too often characterized by different, if not divergent approaches, this trend towards global convergence in privacy standard is and is a very positive one that brings new opportunities and tangible benefits to increase the protection of citizens when their data is transferred abroad, but also to facilitate data flows and thus trade. And that brings me to my second consideration, which is, of course, might again seems to state the obvious, but the importance of data flows for individuals, governments, companies, and more generally society at large. That importance, I would say, is an inescapable fact in our interconnected world. Data flows constitute an integral part of trade, cooperation between public authorities, but also social interaction. In that respect, unfortunately, the current COVID pandemic highlights how critical the transfer and exchange of personal data are for many essential activities: continuity of government and business operation, developing cooperation in scientific research, on diagnosis, treatment, vaccines, fighting new forms of cybercrimes, support successful exit strategy, contribute to the economic recovery. If you were expected me to address Schrems 2, you might be surprised that I'm starting with these two rather obvious considerations. But it's because I think it's against this background, and more than ever before, that it appears that protecting privacy and facilitating data flows have to go hand in hand. And at the same time, that there's, of course, a difficult questions, almost a dilemma that, for instance, the Schrems 2 judgment, but also many other initiatives and decisions and judgments around the world trying to address. How to reconcile those two imperatives: the protection of privacy and the need to ensure that data can flow, can move around the globe. When sometime and often it's moving data is a matter of one click or two. In other words, how do you ensure the continuity of the protection of rights in a borderless interconnected world? That's the issues that ultimately, bottom line, I would say, is at the core of a decision such as the decision of the Court of Justice you mentioned, or the decision of the French Conseil d'État you also mentioned. And this, contrary to what is often thought, is not a European issue, or not exclusively, fortunately, a European issue. It's and I'm saying fortunately because this is not an issue that the EU is trying to address alone or wants to address alone. This is this need to reconcile privacy and data flows, or I would say, or to make privacy a core element of data flows and of trusted data flows, is, for instance, at the center of, at the core of an initiative launched by the former Japanese Prime Minister Abe, an initiative called Data Free Flow with Trust, which has in the meantime been endorsed by the G20 and the G7. This recognition that data and privacy are strategical assets that require protection is also more and more relevant in the US context, not only because you see the development of legislations at state level or the proposal for legislation at federal level. But if I look, for instance, at an initiative launched by State Secretary Pompeo in August, Clean Network Initiative, which is suggesting, for instance, to use privacy and data protection as one of the criteria to identify high-risk suppliers of network elements. I think that shows also that, coming probably from different angles, different legal traditions, and looking at these issues still in a slightly different ways, we are actually addressing very similar challenges. And I really believe and genuinely believe that while, yes, we have to address complex and difficult issues, such as the consequences of the Schrems 2 judgment, there is probably today more common ground between the EU and the US and other like-minded countries than there were a few years ago. When and I have, as you have kindly recalled, I have been dealing with these issues now for some years. When I started to travel to the US to discuss these privacy issues, the question was often, why are you doing this in Europe? Why are you trying to adopt the GDPR? The why question was very present. Today, I must say that question is much less there. We have discussions about the how and why did you choose that solution or that approach rather than another one. But that's in a, I would say, quite limited amount of time is a very significant evolution. And therefore, it is, I would say, on those shared value and common challenges that it is on the basis of the shared values and the common challenges that we need to build and to work on to face, as I said, similar challenges, and we probably prefer to face them together and define some global rules of the game that are more and more necessary, if not indispensable, rather than leave that job to other actors which may not share those values and may not have identified the same challenges, but also probably the same opportunities. So that's what I wanted to, and I hope I was not too long. I wanted to say as a as some introductory remarks, and actually why I was very much thinking aloud while sharing them with you. So I hope they were clear enough. But of course, having said that, I'm happy to answer any question on Schrems 2, La Quadrature du Net, Privacy International, and the many sagas around them. Thank you, Alan, and looking forward to contributing to the conversation and answering as many questions as possible.
Thank you, Bruno. But one quick follow-up before we turn over to Dr. Jelinek. If I'm understanding you correctly, you sound actually quite optimistic or very positive. Maybe those are optimism and positivity, perhaps they're distinguishable. But you talk about shared values, similar challenges, common ground. But yet there is obviously conflict between the two jurisdictions. That is perhaps epitomized by the Court of Justice. Can the audience take away from your perhaps optimism or positivity that the Commission will be issuing some guidance before too long that will help organizations, companies, governments get beyond the concerns of possible cessation of data flows? Will the Commission be doing something contributing to the development of a solution here?
Yes, the short answer to that is yes. We will very soon, and here, sorry if I then enter into the lingo of data protection, we will very soon issue a draft, modernized standard contractual clauses. I'm in my office today because actually we were finalizing the draft with some of my colleagues. Of course, we are keeping social distancing. So this is live from Brussels. And we are, of course, very closely contributing to the development of guidance by the European Data Protection Board. But I will leave Andrea probably explaining that. Look, optimism, some might say the half full or half empty glass. What I tried to explain is that this judgment is not an isolated event. It's a judgment. One might agree with it, disagree. For us, it is the judgment of the highest court, and it's a judgment of constitutional nature. So we just comply with it. But I understand that there might be many commentators and observers who might have different ideas. What I wanted to explain is that the judgment, good or bad, is addressing an issue which is common to a number of countries around the world, of, I would say, like-minded countries, which want both to embrace the opportunities of the digital economy and of the economy in general, but are also aware of certain challenges, concern, and of the need to protect effectively certain basic, call them civil rights, individual rights, fundamental rights. So that's the context in which this judgment, as well as other judgments or decisions, take place. And yes, I think that those issues are much more much higher on the agenda of Europe, the US, Japan, and others, and that therefore this might facilitate the development of long-lasting solutions. And I don't want now to expand too much on this, but I think we are already seeing some signs in some organizations, so some of the international organizations, if one believes in multilateralism, of those possible solutions or elements of solutions.
Thank you very much, Bruno. Dr. Jelinek, opening remarks from you. We look forward to hearing your thoughts.
Thanks so much. Ladies and gentlemen, dear fellow panelists, dear Ellen, first of all, I want to thank you for having invited me. And second, I want to thank Bruno because he already showed us the big picture so that I'm able to concentrate on the real data protection issues, which are embedded in the big picture Bruno just showed us. And I think it was really important that he dig very deeply in our shared values. I think this was very helpful for all of us. Though the Schrems II ruling surely needs no introduction for this distinguished audience, allow me to briefly summarize it in order to explain to you what actions the European Data Protection Board has undertaken and will take in the coming weeks. On July 16th, as you all know, the European Court of Justice invalidated the EU-US Privacy Shield. According to the court, US laws on national security, public interest, and law enforcement allow for interference with the fundamental rights of persons whose data is transferred to the US. As a result, the essential equivalence requirement for the adequate protection of data is not satisfied. On these grounds, the European Court of Justice found the EU-US Privacy Shield to be inadequate and invalid. The invalidation of the Privacy Shield had immediate effect. This means there is no grace period during which exporters can keep on transferring data to the US under the same conditions as prior to the ruling. Secondly, even though the court upheld the validity of standard contractual clauses as they are right now, you just heard from Bruno that the Commission is working on the new set of SECs. It put forth important qualifications for data controllers to when using such SECs. Companies relying on SECs, but also on binding corporate rules or BCRs, must assess on a case-by-case basis whether the recipient country offers a level of data protection that is essentially equivalent to European law. It is important to note that the threshold set by the court for transfers to the US applies not only for US, but for any third country, as Bruno already mentioned. As you know, under the GDPR, a third country is a country other than the EU member states and the three additional EEA countries, Norway, Iceland, and Liechtenstein. The court highlighted that it is the responsibility of the data exporter and the data importer to assess whether the level of protection required by EU law is respected in the third country concerned in order to determine if the guarantees provided by the SECs or the BCRs can be complied with in practice. The European Data Protection Board is acutely aware of the impact of the Schrems II ruling has on hundreds of thousands of US and EU businesses of every size and in every sector. The EDPB understands the need for organizations to have a tool that allows the lawful transfer of data to third countries and of the difficulties they are faced with following Schrems II, especially if they are a small or medium-sized organization. We have therefore I think you all know this, immediately taking action by issuing a statement shortly after the ruling, followed a week later, I think it was on the 23rd of July, by the adoption of a frequently asked questions document addressed to controllers. In our FAQs document, we analyze the court's ruling in greater detail, in particular the obligation for exporters or controllers to assess the legal regime of the country they are exporting data to. Exporters can contact the data importer to verify the legislation of its country and collaborate for the assessment, specifically for matters such as the right to privacy, data protection, and government access to personal data. If the recipient of the data is unable to comply with the SCCs because of competing obligations to which it is subject, exporters and recipients will have to assess together if adding supplementary measures would ensure a level of protection of personal data that is essentially equivalent to the level of protection guaranteed within the EEA. If so, they may then be able to proceed or continue transferring data to the third country. If, however, exporters come to the conclusion that they cannot meet the essential equivalence standard, they have the obligation to suspend or end the transfer, or they have to notify their data protection supervisory authorities if they intend to continue transferring data. We, the supervisory authorities, have the task to suspend or prohibit a transfer of data to a third country pursuant to SCCs if the protection of the data transferred cannot be ensured. Many businesses rely on SCCs to transfer data to countries outside the European Economic Area. The ruling has far-reaching effect on these businesses, giving controllers an important responsibility while also putting a major obligation on the shoulders of supervisory authorities. As invited by the court, in order to avoid divergent decisions, the supervisory authorities will work within the European Data Protection Board in order to ensure consistency, in particular if transfers to third countries must be prohibited. This work will also take place in the context of the cooperation of supervisory authorities on cross-border cases. In our FAQ document, we also address the use of Article 49 derogations as a basis to transfer data from the European Union to the US. In EI, explicit consent, transfers necessary for the performance of a contract and transfers necessary for reasons of public interest. While these derogations remain a valid lawful basis for transfer, they cannot become the rule and must be limited to specific situations and to a strict necessity test. As a next step, following our FAQ document, during the first plenary after the summer, this was on September the 4th, we have created a task force that will develop and is going to develop additional information and recommendations for controllers and processors. The European Data Protection Board is currently preparing recommendations on the steps exporters may follow in collaboration with importers to identify where supplementary measures are needed to reach an adequate level of protection. The recommendations will mention the factors exporters could consider to select measures of contractual, technical, and organizational nature that can be effective in a third country. I already mentioned at an interview 2 weeks ago that we try to be ready in about 2 months. This means from now on, it should be ready in about 6 weeks at the latest. Just to give you an update on the working and also on the workload. However, the implications of the judgment are wide-ranging and the context of data transfers to third countries very diverse. Therefore, there cannot be a one-size-fits-all quick-fix solution. Each organization will need to evaluate its own data processing operations and transfers and take appropriate measures, bearing in mind the legal order of third countries. In addition to the task force on supplementary measures, the board has created a task force to look into complaints filed in the aftermath of the Schrems II judgment. A total of 101 identical complaints. Meanwhile, 2 were withdrawn, and we have 99 identical complaints have been lodged with supervisory authorities, with all the 30 supervisory authorities within the EEA. And regarding the use of Google and Facebook services, which involve the transfer of personal data, the complainants are represented by the NGO NOYB, whose honorable chairman is Max Schrems, and claim that Google Facebook transfer personal data to the US, relying on the privacy shield or on standard contractual clauses, and that according to the recent judgment of the court, the controller is unable to ensure an adequate protection of their personal data. The task force will analyze the matter and ensure a close cooperation among the members of the board. We will continue our work to provide information on the implications of the rulings to controllers and processors. And we will review, if necessary, and update our existing guidance documents, such as the European Essential Guarantees paper. The EDPB also follows the actions supervisory authority are taking at the national level in the follow-up to Schrems II very closely and promotes the exchange of information between us. Let me conclude with the following. The EDPB stands ready to provide the European Commission with support and assistance to build, together with the US, a new framework that fully complies with EU data protection law in line with the judgment of the court. The European Data Protection Board intends to continue playing a constructive part in securing a transatlantic transfer of personal data that benefits all our citizens and organizations. Thanks for your attention, and if there are any questions I am able to answer and are not already answered by Bruno, I will be there. Thank you.
Thank you, Andrea. Very much appreciate your comments, as well as the focus of the EDPB on providing practical guidance as quickly as possible. I think hearing from Bruno that the draft SECs should be available imminently, I think I understood from his comments and your indication that additional guidance for the case-by-case assessments that organizations transferring data need to make now to each country. With regard to the recommendations on supplemental measures, that are you able to provide any to foreshadow what may be involved? You spoke generally of technical organizational measures and so on. That sounds perhaps like encryption. Are there other, what sorts of guidance can you give us about what to expect? And among those supplemental measures, is there a factor to be taken into account regarding litigation in the EU courts for the redress capability that the Court of Justice required? That is to say that under the SEC's aggrieved parties in the EU can sue in their domestic courts in the EU. So some guidance as to what we can expect regarding the forthcoming supplemental measure recommendations.
Thank you for this question, Alan. But as I already said, we are going to discuss this within the next weeks, and the expert subgroups are working on this very thoroughly. And I don't want to disclose anything because it's not fair if the people are still working and I'm already disclosing our ideas, but you can be sure there will be a lot in the papers, and it will not be a one-pager.
Thank you, Andrea. Forgive me for trying to extract some preliminary perspectives on where you may be heading, but I understand entirely that it's still very much of a work in progress, and you're listening to internal voices and external ones as well. Let me turn now to Ken Propp for his perspectives from the United States and internationally as well with regard to digital commerce. And
thank you, Alan. I'm glad to have the opportunity to speak to all of you today. I first wanted to echo something that Bruno said at the outset, which is that despite the current difficulties, this really is a transatlantic community that works on privacy issues, and we have not gotten it right yet, but I think the conditions actually are propitious, as he says, to aim for what the Commerce Department called in its recent paper a durable political solution. And I thought that was an interesting phrase because it makes clear that what is needed is not just a legal solution. The legal solution is obviously a big part of it, but if we are going to have a stable set of circumstances for transatlantic data transfers, it needs to have a number of elements that make it politically stable as well. And so what I would like to do is to briefly sketch out what I think a few of those elements might be. As Dr. Jelinek has just explained, there is enormous effort going into buttressing standard contractual clauses. That's what the European Court of Justice has insisted upon. But obviously, their future as the principal data transfer mechanism in the transatlantic arena is also uncertain, as she indicated herself by mentioning the cases brought by Max Schrems's None of Your Business organization. And there are proceedings in courts as well as before DPAs that create considerable uncertainty about SCCs. So I would anticipate that there will be a further effort by the U.S. government and the European Commission to focus on the specific problems with Privacy Shield that were identified by the Court of Justice. It's not an easy exercise. Two previous agreements obviously have been struck down, but the court has given very clear guidance on what is necessary at this point. And obviously addressing the issue of the lack of individual redress in the United States for foreigners who are the subject of surveillance is something that is at the top of the agenda right now. I have been doing some writing and thinking on this subject, and I think that there are existing privacy-related institutions in the United States that can be adapted to try to create better remedies in this area. One can work, for example, with institutions like the Privacy and Civil Liberties Oversight Board, which has important roles now in the counterterrorism area, but conceivably could have a broader role. There is the Foreign Intelligence Surveillance Court, which does institutional oversight of surveillance that's conducted under the Foreign Intelligence Surveillance Act, Section 702. It could conceivably be possible to vest them with individual oversight responsibilities as well. There is some serious thinking that is underway in Washington on these subjects, and I personally am hopeful that it will yield some fruit. A second element, I think, of the equation for the United States has to be passage, finally, of a comprehensive U.S. privacy law. This would respond to the criticisms in Schrems 2 by establishing baseline privacy rights for individuals on the use and handling of their personal data, generally parallel to those that are in the GDPR, and empower an independent regulatory agency to enforce them. In enacting such a law, the US government, I think, would send an important signal to Europe and to the rest of the world that it has entered the global privacy law mainstream. And I think the credibility that would be gained from such a law would be very significant for future international negotiations. A third element is one that is perhaps a little more controversial in privacy circles, and that comes from the area of trade law. There have been efforts by the US government in recent trade agreements to include protections for digital trade and specifically for data flows. And these protections are drawn from World Trade Organization precedent. They're included in the digital trade chapter of the US-Mexico-Canada Free Trade Agreement, for example. Also in a digital trade agreement that was reached with Japan last year. And I would note they're also currently under negotiation with the United Kingdom in the bilateral agreement that the US is pursuing there. The basic concept here is that there would be a protection for cross-border transfers of electronic data for business purposes. And this would guard against measures that are protectionist or discriminatory. It would not outlaw transfer restrictions that are based upon privacy laws, but it would insist that they not be done on an arbitrary basis or as disguised restrictions on trade, and that they be tailored very narrowly to achieve public policy objectives. This was on the table in the negotiations between the United States and the European Union for the Transatlantic Trade and Investment Partnership, TTIP, that were pursued and failed during the Obama administration. And it was an opportunity that the European Union was not interested in pursuing at that time. They had particular difficulty with the provisions that I've just described. But I think it is a subject that is worth revisiting in the future. It will be interesting to see if the United States and the United Kingdom can come to an agreement on a data flows provision, because the UK, after all, has adopted a privacy law that is largely taken from the EU privacy law. And so I think there could be some inspiration there for a future discussion between the US and the EU. The final element that I would mention is the possibility of some multilateral engagement on the subject of government access to data. Dr. Jelinek mentioned that even though Schrems 2 is focused on US surveillance, it lays down requirements that are applicable to data transfers from the EU to any third country. My sense is that the focus in Europe has now expanded beyond surveillance coming from the United States. And indeed, there were important decisions that came down from the Court of Justice just in the last couple of weeks, looking at surveillance regimes of EU member states themselves, UK, France, Belgium, and their bulk data collection practices, and an assertion of the applicability of EU fundamental rights to those activities. So I think the moment may be right for a broader look at government access to data. And the Organization for Economic Cooperation and Development in Paris, the OECD, has begun a dialogue on comparative practices in this area. I understand the US government is participating in that. The Council of Europe in Strasbourg, which has an important comparative law function, is also interested in undertaking work on this subject. And I do feel that discussions on comparative government surveillance regimes could lead to a broad consensus on the types of legal controls that are needed in democratic societies. If you talk to people in the US government and the Justice Department and the intelligence community, they feel very strongly that the controls that exist on these types of activities within the US government compare favorably with those in other countries, including in Europe. And so I think a discussion on these and some agreed principles in this areas could very much help the transatlantic political atmosphere for data transfers. Let me just mention in closing one other point, and this is something that came up in the Commerce Department white paper, and it has to do with intelligence cooperation between the United States and Europe, which I think is something that sometimes gets lost in the focus on the privacy dimensions here. In the white paper, the US government went to some length to describe the important intelligence equities that are at stake across the ocean. And they declassified numerous examples of instances where the United States had provided intelligence to EU member state governments that had served to disrupt terrorist attacks, enable weapons proliferation to be interrupted, for example. There is a view in the European privacy community that these activities do not qualify under the derogation for public interest in the GDPR because only activities that arise under European law meet that standard. And I think this is really a very narrow perspective and not a self-evident one to me at all. I think one needs to take a broader view of national interest here. Why is it that the national interest of the European government is for some reason not implicated when it receives important intelligence information from the United States government that serves to prevent a terrorist attack? I think thinking like this has to become part of an overall solution, an overall political solution as the US government seeks here. I'll stop here and invite your questions. Thank you.
Thank you, Ken. That was terrific, and thank you for introducing the trade aspects, the WTO precedents, and some possible models that we would have had in TTIP, as you point out, and that we have introduced in the U.S., Mexico, Canada, and the Japan agreements. I think that everybody who's listening to your comments is likely to agree with what I will now say, which is everything you say makes such good common sense, and it seems so unassailable. For example, the last point on the national equities about the contribution to the security of Europe through the beneficial mutual relationship with the U.S. intelligence community. But the fact of the matter is that there is a judgment that is final, as Bruno pointed out, of the Court of Justice of the European Union, and like our Supreme Court, which is final not because it's it's final not because it's not infallible, but it is final, like the Court of Justice of the European Union. So they may have missed some of the common sense and legal points that you've made, such as the fact that U.S. Safeguards actually compare quite favorably to those of the EU, and in many regards, in fact, perhaps even most, are stronger. But nonetheless, the Court of Justice in Trends 2, as in Trends 1 before it, has found U.S. standards failing compared to an idealized version of European rights that are in the Fundamental Charter of Human Rights, not in the actual practices of the EU. How do we find the durable political solution when it's very difficult for the privacy negotiators, the trade negotiators, to deal with national security implications? And the Court of Justice is not inclined, as it's demonstrated, to address the comparison of US and EU surveillance standards, but rather the comparison of US surveillance safeguards to the Fundamental Charter of Human Rights without taking EU practices. What form of engagement do you think can take place in order to get an actual political solution that would bind the Court of Justice? Is it a treaty? Is it what sort of approach would you suggest?
Well, I do think that some form of negotiated solution between the United States and the EU writ large, whether that takes the form of a treaty or something lesser, is the way to come to a broader solution. And you know, in terms of bringing some of these other elements into play, I would just note again that the Court of Justice may have actually started the discussion in that direction by its recent ruling regarding EU member states and their own national security activities, and bringing some of those within the scope of EU law. I think the member states are able to engage in this discussion through the Council of the European Union. The Council is deeply involved in negotiations of international agreements. And I think it is perhaps through the Council that one would see some of the elements that I've mentioned here brought to bear in the discussion.
Thank you, Ken, and thanks for introducing the element of the European Council, and perhaps that can be a vehicle for establishing a process that could be a counterpoint to the Court of Justice. Bruno, you have great perspective, not only in the instant development of new SECs, but also in the umbrella agreement and other work on the law enforcement directive. Could you perhaps, could we extract from you any comments on what the supplemental measures, safeguards, what you might recommend for organizations that are exporting and importing data into the United States ought to be considering, and whether there's a trade angle here or any other political process where the issues at hand can be addressed between the two jurisdictions and hopefully resolved or at least ameliorated.
Yeah. Well, thank you very much. Ken has said so many things, many of which I fully agree with and which are fully part of our approach. I also noted that he has already chosen who will be the negotiator on the EU side. He knows too well how Brussels works and not to know that it will be the Commission. And of course, the Commission always acts under the control of the Council and the European Parliament. And the Commission work, as any other institution in the EU, is of course to comply with a judgment of our highest court. And indeed strike, in complying with that judgment, strike we hope the right balance between a number of considerations. This brings me, if you allow me, very quickly to this question of national security. Of course, the US has national security needs. Our member states have national security needs. There's an enormous benefit in exchanging data and information to protect the life security of our citizens on both sides of the Atlantic, when it comes to national security, when it comes to law enforcement. I don't know where the two of you see that very restrictive reading of derogation. Derogation, of course, take also into account the reciprocal aspect of a public interest, is that they might be actually a public cooperating internationally on something might already be the expression and the sign of a public interest. I'm very happy to say that, because the Commission, on behalf of the EU, has argued that point and litigated that point before the US Supreme Court in the Microsoft case. It is expressed in our pleadings. That's, I think, one aspect that and I believe that even the EDPB guidance on derogation reflect that to a certain extent. The problem is that derogation can only be used under the conditions and the strict condition. Derogation, regardless of whether they are public interest derogation, consent derogation, contract derogation, the condition under which derogation can be used, which is for rather limited transfer, I wouldn't say one-off, but limited transfer of a limited frequency, volume, etc. That is true and will always remain true. The problem is that when we're talking about TREMS tools and we're talking about how to assist compliance by our companies, we are talking very often about a more structural form of transfers that require other tools than derogation to be based on, such as standard contractual clauses. And that's where I think there's a need for a modernized instrument and support in using those modernized instruments in compliance with the Schrems II judgment. On trade, we also have an approach, and we have, by the way, tabled an approach, a text in the WTO e-commerce negotiation, in all our bilateral trade negotiations on data flows. We believe that no modern trade agreement can today not have a chapter on digital trade and not have a provision on data flows. And I'm not going to describe the text that we are tabling in all those negotiations, but the text is an attempt to distinguish what is, I would say, digital protectionism and data protectionism, and what are lawful reasons to exercise the regulatory autonomy parties should have on data protection as on other important considerations, health, national security, etc. So just to signal that it's not only that we think that this should be part of trade negotiation, but that we have an approach and a text that we are systematically tabling in our negotiation. And that text is, for the moment, the only one in the world that outlaws, prohibits a number of data localization measures and requirements. So that's certainly also part of the EU approach to these issues. Third, totally agree on the need to discuss and possibly agree on common principles, if possible, common rules at international level, because, as I said, this is not only an issue for the EU and the US, it's an issue for many other countries in the world, which also want to show that their system is different from the system of, I would say, different actors, which have a much more, to use an understatement, lenient approach to privacy issues, and have sometimes a very broad, excessive, disproportionate forms of access to data. This is it's at the center of a number of cases of issues you're addressing in the US, in the TikTok case, in concerning Huawei and others. Japan has, I think it's just one of the starting point of the Japanese initiative on data free flow with trust, how to organize the free flow of data between countries that share similar values and are ready to put in place similar protection and safeguards. And I totally agree with Ken, the work in the OECD, in the Council of Europe, that we as EU not only very much support, but also contribute to, is part of that, it can be part of a more long-lasting, and quote the Department of Commerce, on that at least we agree, of a more durable solution. And to come finally to your point, Alan, and now we go back to the technicalities of Schrems 2. Well, I think there's a very important aspect of Schrems 2, and here I agree also with Andrea. Neither the SCCs nor the guidance of the EDPB will give you a one-size-fits-all solution, because this is not what Schrems 2 is telling us. Schrems 2 is not about a binary approach, transfer to country X are fine or not. Schrems 2 is tells you you have to do something which is, by the way, part of the GDPR or any modern privacy law. You have to do a risk assessment. This is part of your obligation in terms of accountability. And you have to look at a number of elements, circumstances, says the court, of the transfer. And we can imagine the nature of the data, the identity of the addressee of the transfer, whether that addressee is subject to certain laws or not, the type of business model, the volume of the transfer, etc. And on that basis, you have to determine whether there's a risk, a likelihood. There are many terms that are being aired and discussed of excessive access. And if you identify that risk, then you might want to be able to transfer the data, nevertheless, to put in place a number of additional safeguards. So don't expect that the SCCs or the guidance will give you a sort of exhaustive prescriptive list of solutions. We would lose, some will be surprised that I use this term, but we will use the flexibility of the judgment of the solution provided by the court. But what certainly can speak then for the SCCs, I know I have a certain idea of what will be in the guidance, but I very much respect the fact that this is still being discussed under secrecy. But in the SCCs, for instance, you will have the SCC will be a sort of toolbox. You will have a sort of checklist on a non-exhaustive basis of elements to be taken into account in that assessment of the circumstances of transfer. And you would have examples of safeguards, which you have mentioned, Alan, and there's a lot of discussion about encryption. Encryption can be one of the safeguards and can be one of the technical/technological safeguards. There might be others. Once again, depending on the nature of the data, on the type of business model, I think a situation between a controller and a processor is very different from other situations. A situation when you transfer, when you are, I don't know, two companies transferring some limited HR data is very different from the situation of a transfer taking place in the context, for instance, of a social network, etc. But you will have, for example, of safeguards. Some will be of a technological nature. Some others will be of more of a organizational, if you want, legal nature. And we are basing ourselves very much on what we are hearing from the market. They are best practices. We have used them, by the way, in our litigation to defend the STCs on, for example, that requests, access requests should be systematically review the legality, lawfulness, if there are grounds to, if there are elements that would show that they are excessive, for instance, they should be challenged. There should be, if possible, some information on that between the importer and the exporter. Some data protection of privacy principles, such as the principle of minimization, have probably a role to play in how you answer to these access requests. It's important to neither, I'm a bureaucrat, so you might think that I'm just sitting in my grey office in grey Brussels. But of course, we understand that companies are not governments and are not legislatures. They don't have themselves the power, the role, the responsibility to shape national security laws. We understand that. Even the Brussels bureaucrats understand that. And therefore, the elements and the tools that we are using and that we develop in the SCCs, but let me say that I don't think that the guidance will go in a very different direction, and there will be ways also to during our own decision-making process to make sure that the two goes in a convergent and synergetical way. We are perfectly aware of what is the role of companies on the one hand and what is the role of governments, including to find that political, durable solution you and others have mentioned. I've tried to cover everything I could pick up, but probably I've forgotten a number of issues. Will be for our next conversation probably, and sorry again if I've been a bit long.
No, Bruno, that was terrific. You give bureaucrats a good name, so thank you for your interventions and your comments there. Andrea, I wonder if you could respond with your thoughts as you wish, but in particular, Bruno mentioned the flexibility of the judgment, which I thought was interesting and positive, and also the public interest component of possible justifications and derogations that might legitimate some transfers. I will say, and perhaps I'm operating under a bit of a misapprehension, but perhaps others in the audience are as well. I had been of the view that EU law, as interpreted by the Court of Justice, said that the public interest needed to be established under the laws of EU member states as opposed to non-member states. So I wonder if you could just respond to what Bruno said, in particular on flexibility and public interest.
Thank you, Alan, for this question. As Bruno already promised at the beginning of our conversation, he already answered everything and every question which would have been possible asked. I'm very grateful for that. And though we are sometimes of different opinion on this issue, we share not only the same continent, we share the same point of view. I think it's though the court's ruling shows us the flexibility. It's quite sure that for Article 49 derogations are derogations, and they should be kept as what they are. And I fully agree with what Bruno has said on this specific topic. It's really important. Thanks.
Thank you. One follow-up: is it reasonable for data exporters and importers operating under SECs to assume that they can safely wait for the new draft of the SECs, to wait for the EDPB guidance? So in other words, not to take precipitous action at this time, but to agree that they will review the draft SECs, the final revised SECs, along with the EDPB guidance, and when those materials are issued, to revise their SECs accordingly and their practices accordingly, and not to that they're not at risk immediately in waiting for the additional guidance from the Commission and from your group, the EDPB.
Ellen, as I already said in this session at the beginning of what I said, and during other sessions since the 16th of July, the European Court of Justice invalidated Privacy Shield with immediate effect. And as you have to follow the judgments of the Supreme Court, we in Europe also have to follow the judgments of our highest court. And so there is no grace period, but as everybody knows, we are investigating every complaint and everything very thoroughly, and we have to look into every detail, but there is no grace period.
Understood. Thank you. Ken, I wonder if you'd like to respond to what you've heard from Dr. Jelinek and Mr. Gencarelli?
Sure. I just would emphasize that what we have here is a crisis. It may be a slow motion crisis because enforcement actions are not occurring at the current time. The cases that are before the regulators and the litigators will take some time to work their way through their procedures. But we are currently without Privacy Shield, which was the principal transfer mechanism for more than 5,000 companies. Companies are scrambling and will be scrambling to adapt standard clauses to the new circumstances dictated by the court, by the commission, by the EDPB. This is not a situation that can continue indefinitely without consequence. And for the time being, the U.S. government has exercised forbearance and is approaching this in a calm fashion. I hope that will continue and that the types of initiatives we've talked about today will have time to take root and to build towards a permanent solution. But I just would stress that this is not business as usual.
Ken, do you think that adequacy for the United States is should be the objective and would be warranted and could be the durable political solution that you mentioned, and which to the extent that it could be established in a manner that would survive the Court of Justice review? Is that what we really should be heading towards, adequacy for the United States?
Well, I think as a practical matter, that is going to be where the U.S. government is putting its emphasis in the short term, simply because that's the framework that EU law requires. But adequacy has its limitations. It's been interpreted in an extremely restrictive way by the Court of Justice. Until a few years ago, no one knew that adequacy actually meant essential equivalence, and that essential equivalence actually meant absolute equivalence in a number of circumstances. So this is really a very tight framework for a foreign government to fit into. And I think that as time goes on, the European Union may well have difficulty, not just with the United States, but with other countries in fitting them into the adequacy framework. It's already a framework that that only works for a very limited number of countries. So I think the door is open to broader solutions, but at the moment, I at least can't say what that might be.
Mm-hmm. You know, I think that your comment, Ken, about adequacy converting to essential equivalence and then being upgraded to absolute equivalence, I would go even further and say that what the Court of Justice is requiring is absolute equivalence to an idealized version of EU data protection and privacy rights under Article 7 and 8 of the Fundamental Charter of Human Rights, and that there's not a realistic comparison of actual equivalence of privacy standards, both for the commercial sector as well as the national security sector. You mentioned in your remarks at the outset about greater reliance on the Privacy and Civil Liberties Oversight Board, perhaps, PCLOB, and the Foreign Intelligence Surveillance Court. The Court of Justice really did not focus on PCLOB and the powerful oversight role of the Foreign Intelligence Surveillance Court, the FISC, and the Court of Justice disparaged really the significance of Presidential Policy Directive 28, PPD 28, which accorded privacy rights and protections to non-U.S. persons. Do you think that the U.S. government is developing a new suite of possible responsive measures that would be designed to reassure the European courts and to facilitate the ability of U.S. companies in their self-assessment of of equivalence between the United States and the EU around the use of the PCLOB, the Foreign Intelligence Surveillance Court, the minimization standards required under PPD 28?
Well, look, I mean, the U.S. government litigated extensively about the merits of its privacy protections in surveillance before the Irish court and then before the Court of Justice. There were extensive factual findings on that, and in the end, the Court of Justice simply was not persuaded. So there's no longer any point in litigating that, and I think actually that may be one of the demerits of the white paper that the Commerce Department has developed, is that there's a tone to it that continues to press arguments that actually haven't succeeded. So yes, it is necessary that there be new thinking at this point, and I think that message from the court has gotten through to the U.S. government. There is an active interagency process going on in Washington right now, and I think they are looking broadly at what types of steps could be taken. Some of them could require change in U.S. statutes. That's a hard proposition, particularly given our current legislative situation. So it may be that they will be looking for steps that can be taken without changing U.S. law. I think we may be seeing some creative thinking. There was an effort to do this in the Privacy Shield negotiation itself, as Bruno well knows, with the development of the Ombudsperson institution. But that was found wanting by the Court of Justice. So it's time to do something a little more deeply embedded in U.S. law, and that's why I recommend looking at the PCLOB and the Foreign Intelligence Surveillance Court.
Thank you for that response, Ken. One point that I would mention is that while relitigating Schrems 2 is a bad idea because there's not a vehicle or forum for it, and Schrems 2 kind of spoke to the issues. But as Bruno mentioned, and as Andrea knows, each company has to undertake its case-by-case, country-by-country self-assessment as the judgment in Schrems 2 required. And I would submit that, as Bruno characterized it as a risk assessment, a lot of the factors in the U.S. government white paper, the Commerce white paper that was jointly issued with Justice and ODNI, the factors there, which you could view it as arguments to relitigate Schrems, in fact, are also the considerations that companies should consider in undertaking their own risk assessments with regard to their national security exposure in the United States. I did want to ask a question that we have from the audience regarding the WHOIS database and anonymity that the GDPR and the European privacy laws might encourage in terms of availability of who is behind the registration of various different domain names. U.S. government agencies consider it critical to help protect consumers from harm and to identify the people behind domain name registrations. Andrea, is the WHOIS database of ICANN and registration of domain names and privacy for that, is that a matter that the EDPB has a point of view on and has under any sort of active consideration?
The ICANN and WHOIS issue has been an issue since 2012 in the former Working Party 29 and afterwards at the board level. And we issued guidance. I think the last was 2019 to support them to fulfill the measures. And it was never enough we gave for them, but we were still and always giving advice and supporting them. So it's not a fresh issue. It's a long-lasting issue within the Working Party 29 and afterwards already in the board. So it's nothing new.
Thank you, Andrea. Bruno had mentioned the Commission's perspective on prohibitions on data localization. Is data localization, is that an issue that comes before the EDPB?
It is true that the idea of forcing companies to store at least some of the data in Europe has been gaining ground in the EU in the past months. You're right, and also Bruno mentioned it. While I personally believe there are some merits to ensuring a certain degree of data sovereignty, this is not in itself a long-term solution, I think. The EU does not oppose international data flows per se, which may indeed be necessary for economic growth and to tackle global problems such as now the COVID-19 crisis. The EU opposes international data flows that violate the fundamental rights of EU citizens and that are thus detrimental to them and to the values they share. So EU's reinforcement of its citizens' rights to data protection and other fundamental rights is contributing to reinforce the rights to privacy and data protection of citizens from around the world. Governments are seeking to maintain their countries' access with the EU's data protection standards. And I'm really proud to see that the EU's high standards of fundamental rights combined with its market power are contributing to raising at a global scale the standards of protection of fundamental rights. And I hope that in a not too distant future, countries will be able to meet at the top in terms of protection of personal data and continue their transfers of data for the benefit of their citizens without compromising on their rights. So you see, I'm always positive and thinking of the best and hoping that we agree on the best for all of our citizens, not only now, but also for the future. And for sure, the citizens are also part of the organizations who they work for. And I think so we have the circle which is round, because all the people who are working in the organizations also want to have protected their personal data on both sides of the Atlantic.
Thank you, Andrea. For further indication of the enlightened point of view that you bring to your work for the EDPB and the Austrian DPA, as well as the enlightened thoughts of our other panelists. One of the areas of data flows, and we've come to the end of our time, that we haven't talked about, but Bruno is very actively working on, and he had to leave just a minute early to address the Brexit situation, which of course will pose challenges different from, but in addition to the transatlantic data flows, the trans-channel data flows. Before Bruno did depart a few seconds ago, he did indicate to me that he disagreed with my view of the standard for essential equivalence. So I should take the opportunity to note that my perspective on that doesn't necessarily represent a consensus. I'll close with the thought of comedy. We've talked about, and Ken mentioned, a durable political solution and multilateral approaches and engagement. I think Bruno discussed convergence as well. I would point out for the audience that in the Cloud Act, something which perhaps from the European side might not be viewed as a model, but it certainly should be taken seriously by all parties. And there's a very extensive statutory attention to the subject of comity and how U.S. courts ought to balance conflicts between U.S. laws, including privacy and government access laws, and the privacy interests of other countries, and resolve those conflict of laws in a very sensible manner. So I would refer the audience and the panelists to the Cloud Act with regard to its attention to the issue of comity. With that, we've come to the end of our time. The comments of our panelists here, Dr. Jelinek, Ken Propp, and Bruno Gencarelli, couldn't possibly have been more timely, more thoughtful, more enlightened, and I think to a great extent reassuring. We have guidance that's going to be almost imminent, I gather, from the Commission on the SECs, further guidance from the EDPB, and suggestions from Ken on perhaps concrete approaches to coming to some sort of a resolution of the difficulties and the crisis, as he put it, in data flows, which are so important on both sides. So I think there's some grounds for optimism in amelioration of the crisis, perhaps resolution of it. So join me in thanking our panelists for great comments.